Hi, Tony DeWitt here, Missouri appellate attorney and a guy who tries to make the law make sense on YouTube. I'm answering a question from a viewer today about the appellate record and specifically how things get into the appellate record. Let's go down to the beach and talk about this. So what is the appellate record? Well, the appellate record is the document that the court works from, the appellate court works from in order to decide an appeal. The appellate record contains two main things. It contains the transcript and it contains the legal file. Let's talk a little bit more about each one of those. The transcript is the stenographic record of everything that was said on the record in the courtroom. Now, not everything is recorded on stenograph at every trial. For example, a court may ask the lawyers to come back prior to trial to discuss a couple of issues and just talk over how things might be going, how many days the case might take, that sort of thing. And you wouldn't need to have that on the record, but anything that adjudicated rights needs to be on the record. And so you'd have a transcriptionist in there and they'd have a little stenotype machine and they would record everything that was said by the judges and by the lawyers and anybody else who happened to be in there at the time. And that is the purpose of the stenograph. It's there to make a record for a later appellate court to use. So what goes on that particular transcript? Well, let's take a look. There are motion hearings, for example, a motion in limine or a motion to dismiss, a summary judgment motion, all of those kinds of things. The hearings on those would be in there. If there was an evidentiary hearing, for example, in a criminal case, if someone had an evidentiary hearing to determine, for example, whether evidence should be admitted, well, that would be on the record and it would be transcribed. Any status conference where any rights are decided, that gets transcribed. The trial itself, from the moment when the judge calls the case until the moment that the trial court says we have a judgment and we're entering it. All of the trial goes in there. During the trial, there will be a conference that occurs between the judges and the lawyers over the jury instructions. It's called an instruction conference, and it has to be on the record because if one party or another objects to the giving of a jury instruction, that has to be done on the record so that the objection can be determined whether or not it was specific enough to put the other party on notice. And then post-trial motions. There will always be a motion for a new trial. There may be a motion for judgment non obstante verdicto, or JNOV, which basically is judgment notwithstanding the verdict. It says, okay, the jury gave them the verdict, but they shouldn't have because there wasn't enough evidence or for some other reason. So all of those kinds of motions are heard on the record, and they are transcribed and are available to be put into the transcript, depending on the rules in a particular court. Not everything that's done in the court may be put into the transcript. For example, if you have one very narrow evidentiary issue, then you probably will have a transcript that features the trial and the part of the trial where that evidentiary issue came up, and then any pretrial hearing where those issues were talked about. Motion in limine will get the judge's feeling on whether or not he's going to admit that evidence or keep it out. All of those kinds of things are relevant to the determination by the appellate court, so they would go into the transcript. Again, that's done by rule, and every appellate court has different rules. Federal rules are very similar to the state rules, but there are little twists and turns in there too. And I don't want to go into the federal rules of appellate procedure because they are generally much more in depth and they relate very closely to the federal rules of civil procedure. And that would That would make this video about 9 hours long, which you probably don't want to sit through. So then the second component is the legal file. And the legal file are all the documents that are filed in the case. But again, only the documents that are relevant on the issue being decided go into the legal file. Let's suppose that the plaintiff brings a case against Hewlett-Packard, and Hewlett-Packard wants to dismiss that action. It files a motion to dismiss and a memorandum in support. And then the plaintiff comes in and files an opposition, a memorandum in opposition. And then HP would come back and they would file a memorandum or a reply memorandum, and then the court would decide the motion. And if the motion is granted, then your record on appeal consists of the petition or the complaint that was filed against Hewlett-Packard and all of the motion documents and motion hearings, any evidence that supported these motions. Usually on a motion to dismiss, you don't look at evidence, but sometimes, like for example, if it's a contract case, the contract would be relevant and it would be included. All of these things go into the legal file because that is relevant to the issue that's being decided. In a trial, there will be multiple instances of error that will be brought up on appeal. For example, there will be evidentiary issues. There will be issues with experts, whether an expert should have been allowed to testify, whether the information that the expert provided was properly disclosed, whether he had a sufficient basis for his opinion. All of these sorts of things come up in the course of a trial, and in that situation, the legal file would contain all of the documents that related to those issues, as well as all of the pleadings, the petition, the answer, or the complaint and the answer, depending on the state law in question, whether it's a complaint or a petition. All of those would go into the legal file, and they would get sent to the appellate court to help them decide the relevant issues in that case. Here's an example. Let's suppose you have a ballistics expert and the motion filed by the defendant in a criminal case says we need to exclude this expert because his opinion is not founded in science. Well, all of the documents that relate to that would then come into the appellate record. For example, the expert's curriculum vitae, his report, the deposition of that expert, the motion to exclude, the memorandums in support and in opposition. And in complex cases, the reason you want to look very closely at just putting in the relevant information and the relevant pleadings is because a lot of times in those cases, the record and the number of pleadings can fill up 15 3.5-inch binders. There are usually a ton of issues that come up in those cases. The thing that governs what goes into the legal file and the record on appeal is the rules. And in Missouri, that's covered by Rule 81. Rule 81.12 says what the contents of the record of appeal are. And here they are. The record on appeal shall contain all of the record proceedings and evidence necessary to the determination of questions to be presented by either appellant or respondent to the appellate court for decision. It is divided into two components, the legal file and the transcript. The appellant shall prepare the legal file. If the electronic filing system permits creation of a system-generated legal file and the court operating rule, that method shall be used. If that method cannot be used, the legal file shall be prepared as provided by Rule 81.12. Well, in the most recent cases that I have done, the record on appeal has been created through the system. And basically, because Missouri has a electronic filing system for all of its court documents, all of the documents are maintained in their original condition inside computers. And all you do is pull off the documents that you need, you put them into a binder, a PDF binder, and you file that with the appellate court. So the contents of the legal file shall consist of a legal file generated by the system and all of the hyperlinked documents referenced therein. The appellant shall designate trial court documents for inclusion in the legal file and submit such designations for filing in the manner provided by the system for the generation of the legal file index. So what are included and what are excluded documents? Well, the rule says the legal file shall always include by designation the pleadings upon which the action was tried, the verdict, the findings of the court or jury, the judgment or the order appealed from, motions and orders after judgment, and the notice of appeal. Matters omitted. No matter touching on the organization of the court or any continuance, motion, or affidavit not material to the questions presented. In other words, the court is telling lawyers throughout the state, don't clutter up my legal file. Then we look at the transcript. The duty of the appellant to order the transcript. Within 10 days after the notice of appeal is filed, the appellant shall order the transcript in writing from the reporter or from the clerk of the trial court if the proceedings were recorded by means of an electronic sound recording. Charges due for preparation of the transcript shall be paid as directed in by the Missouri Statute 512.050. Matters included. The transcript shall contain the portions and proceedings of the evidence not previously reduced to written form and necessary to the determination of the issues on appeal. Now, when you order a transcript, you have to pay for it in advance. So usually the court reporter can tell you within reason what the likely number of pages is and how many dollars per page it's going to cost you. It is not uncommon in even a small trial, less than a week, to have to pay in excess of $1,500 for a transcript. And you have to pay that before you appeal, because you have to get the transcript reduced to a written transcript, because at the time that it was recorded on stenotype, and basically the transcriptionist has to go in and reduce that to writing and put that into the record. So it costs money, and it takes a lot of time for the court reporter to do that. And as a result, sometimes, even though you file the notice of appeal in January, you don't actually get the record on appeal finalized until August, September, October. It's not uncommon to do that. So for that reason, neither party can compile a brief until they have the record, because it's necessary to cite to the record in order to make the issues known to the court. So, for example, one of the things that every appeal has is a statement of facts. And the statement of facts is drawn directly from the legal file and from the transcript. So here is a form of a statement of facts from the brief. I've redacted certain information, but you can see these designations here. Appeal docket number 59, page 1. And then from that point on, it's abbreviated, AD 67-P8. So the court knows the document and the page that they can turn to in order to find the information necessary. And then all of that information then is used by the court to verify whether the actual information that is put forth in the record is accurate. How the record on appeal is used in writing a brief is probably one of the most important parts of appellate advocacy. And the reason that's true is because you can pull facts out of the record, but just listing a bunch of facts doesn't really tell the court what happened. So in most cases, unless it's absolutely necessary to put the actual language that someone used, lawyers tend to characterize the facts. This happened and that happened, and the statement of facts should read like a well-written story. This is the story of this trial. And we walked in on day one, we did jury selection, and this juror said that she didn't think she could be fair, and then she changed her mind and said she could be fair. The court should have struck that juror and didn't. So you've got an appellate issue right there. All of these sorts of things are written in such a way as to be advocative. They are supposed to be an objective statement of the record, but there is almost no lawyer who can help characterizing it in the most favorable way possible to the ultimate result that they want to reach. And then, because the lawyers will have done a ton of legal research before they sit down to write the brief, usually they know what facts to pull out of the record and how to make that record into a good and solid story that the court can follow along and decide, oh my goodness, we really screwed this one up. So that's how the appellate record gets developed. That's how the appellate record is used. Courts use them to find the issues, to make sure that when the plaintiff says this witness testified falsely about this document, that both the testimony and the document are available to the court to determine whether indeed the individual did testify falsely, or maybe they just didn't characterize it the way the plaintiff would have had them characterize it. Like I said, there is a great deal of advocacy that occurs in the writing of a brief, but not so much in the collection of the record itself. That's done by lawyers, and often it's done collegially. I have had situations where I've called the opposing attorney and said, we're not raising any appellate issues with regard to, your expert witness, Mr. Doe. Do you think I need to put in our motion to exclude him and the court's order that didn't exclude him? And they will usually say, no, you're not raising an issue on it. It shouldn't be in there. So the lawyers can work together to keep the record small and manageable and concise and focus the court on the issues where they really have disagreements. Good lawyers tend to get along. They may not like the other person's client. They may not like the other lawyer's case. But we know that we are going to see that guy on the other side of this case again somewhere down the road. And you don't want to leave a bad taste in anybody's mouth. Several years ago, I had a case involving a police chase that went bad, and a couple of people were pretty badly injured. And when we got ready to go do the oral argument at the Eastern District Court of Appeals in Missouri, what happened was the other side missed the date and did not show up for the oral argument. Well, at that point, the lawyers who were around me, their jaws dropped to the floor because the judge, the chief judge of the Court of Appeals, asked me if I wanted to go forward without the other side. And I said, I have forgotten to do things, Judge. It could be a complete, could be a mistake on the lawyer's part, but it could also be a mistake on the documents that were sent. I think it's better if we have a full record and the opportunity for both sides to make arguments so the court is well informed. And I won that appeal. And part of the reason I won that appeal is that when they finished calling that case, the judge stood up and said, and that is how you practice law. And it made me feel good, but more importantly, I knew I was doing the right thing. One of the things I always say on here, you have to be kind to other people. You should never take advantage of somebody who makes an error if you can avoid doing that, because that's the way you make lifelong enemies if you do that often enough. So that's my story today on the appellate record, and hopefully you have found that helpful and useful and something that is worthwhile. If you have any questions, leave them in the comments down below. Like, share, subscribe, all the stuff we ask you to do. And again, be kind, help other people, enjoy your day, and I will see you down here at the beach next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.